As I stated the other times that I've given this, there's bad news and kind of good news. The bad news is the ordinance requires you to have 1 hour of ethics training to serve. The good news is I'm going to do 1 hour of training in about 15 minutes. So if you'll bear with me, we'll do that. I want to start with, and are we going there? Okay, I can't see the presentation. I want to make sure. I'm going to touch very, very briefly on 4 topics, and as I say, I'm going to endeavor to do this in about 15 to 18 minutes, so I can't possibly touch all of the issues that might come up during your term as an advisory board member or an elected official, as the case may be. So I would encourage you to feel free to call our office. I think before the lights get too dim, some of my other attorneys are here. I want to for those of you who hadn't met them, I want to recognize, introduce them. The Deputy City Attorney Ignacio Perez is here. I saw Assistant City Attorney Gary Henriksen is here. I don't know if Isaac or Idis or the others arrived. I didn't see them, but you're always welcome to call our office with any questions that I have. There's also some excellent literature that the city secretary has, so any of these topics that you find that might interest you, we have books that are put out by the state on traps. This one's called Traps for the Unwary. It's for public officials' open meetings handbook. So if you really, really want to study this a little more, you might want to reevaluate your life, frankly, because get a dog or take up golf or do something, but we do have plenty of literature for you to review. I'm going to hit 4 topics. I'm going to hit conflicts of interest, disclosures that you're required to make. I'm going to hit public information, and I'm going to hit open meetings, and I'm going to say just hit kind of those topics that are that tend to come into our office. This ordinance is the city ordinance, and by the way, let me, being a good lawyer, start the preface here and say there's both city ordinances and state law that apply to you as elected officials or advisory board members. They overlap to a large extent. Both the state law and this city ordinance, as you can see in the last sentence here, are what we call cumulative. That means they both apply. So in some cases the state law is more restrictive, in some cases the city ordinance is more restrictive, but whichever it is, you should just assume that the more restrictive requirement applies to you. This is our city ordinance. 2006 is when this was passed. This is actually a very, very good, clear, well-written ordinance. I say that because it was written by the man who's going to be the next mayor of the city of McAllen, Jim Darling. The conflict of interest statute for the state law is covered in Chapter 171 of the local government code. So what do we mean when we talk about conflicts of interest, and who are involved and what do you have to disclose and so forth? And that's what I want to touch on very briefly here. First of all, if you're here and you serve on an advisory board, or if you're an elected official, or if you're an appointed official, or in fact some of the department heads that I have seen here today, most likely these conflict requirements apply to you. And so the safest thing to presume is that if you're operating in your capacity as a board member, elected official, or a department head, that these requirements apply to you. And I'm going to sum it up for you very, very succinctly. And because the rules get into percentages and degrees of relationship and all this sort of stuff, but it's very, I think, very, very simple. And that is, when you're operating in your public capacity, you should not allow your role as a public official, and by that I mean all the people I mentioned before, to enhance or enrichen your private life. Okay, that's the short version. If you serve on a board, decisions that you make, information that you get, you should not use that or allow that to enhance you or your family members' public businesses, your homes, your interests that you have in financial holdings or anything like that. And if you keep that sort of in the back of your mind, the fact of the matter is you normally will not run afoul of these conflict statutes. You do notice that it covers families. I'm only going to hit the things that seem to come up to our office, and that is, we're often asked if a person will come to us and say, do we have a conflict or whatever, and they don't realize that the conflict applies not only to themselves, but also to their family member. What do I mean by that? It means if your spouse owns a interest in a business, or your parent or one of your children own an interest in a business that is impacted by a decision that you're making on the board, it's the very same as if you had that interest yourself, which is, by the way, one of the reasons that it's very difficult for us to head some of this off for you. I mean, we, as city attorneys, we get asked this a lot. I'll touch on that later, but you have to assess yourself, the financial, real estate, and business holdings of yourselves and your close family members. Notice it says, and the lawyers in the room will love this, first degree of consanguinity or affinity, and there's a wonderful little chart for that. I put the chart up there for one reason alone, and that is it's no fun being a lawyer if you can't confuse people every once in a while. And so the short version is, if somebody's related to you, if they're in your family, you should presume that that may create a conflict for you in a particular matter that you may be voting on or acting on, and you should at a minimum come and ask one of us or your own personal counsel about that. If you do determine that, and let me give you some examples, and by the way, this is where the state law and the city ordinance are dissimilar but overlap. The state law just says a special interest. In some other places it uses a substantial interest. In other places it uses the term significant interest. The city ordinance actually gives some examples, but they're not all inclusive. For example, if you happen to serve on the planning and zoning board and you're making a determination about whether to grant or not grant a variance or so forth, and you own real estate that's within 200 feet of where that decision's being made, then you have, under the city ordinance, a conflict of interest. If you have a business that you own an interest in that is impacted by a decision that you're about to make, then you have a conflict of interest. So what do you do about that if you determine that you do have a conflict of interest? Well, it's very straightforward. All you have to remember is these two words: disclose and abstain. You disclose the conflict of interest by going to the staff member that's on your board, or the city secretary or the city attorney's office, and they always have, or should have always handy, a package of what we call conflict of interest forms. You fill that out, you file it with the staff member or the city secretary. That's your disclosure requirement. You've taken care of that. And then abstain. Obviously, you don't want to participate in the decision about which you have the conflict of interest. Now, notice here that I also added another sentence, because this is in fact, I got this question actually last week. Good faith question by a board member who's on a board that normally doesn't have conflicts. We determined together that this board member did have a conflict, and he said, okay, that's fine, so I can't vote, but I can still enter into the discussion, right? And I said, no, you can't do that. In fact, the law specifically precludes that. So if you determine that you have a conflict, not only must you abstain for voting, but you cannot participate in the deliberation related to that particular matter as well. I have seen board members that will go to the extent of, physically getting up and leaving the room during the course of that deliberation, or at least noting for the minutes that they didn't engage in that deliberation. So please be aware of that. If you have a conflict, please don't engage in the discussion. And then when the discussion's all over, say, oh, by the way, I have a conflict and I'm going to abstain. That's not the appropriate way to handle that. As I mentioned earlier, the local ordinance has some examples of that. The state law uses this term quite a bit, special interest. And again, there's tons and tons of case law about that. The bottom line is, if you think that you have an interest that may be affected by something that you're asked to make a decision on, you should please let us know, and we'll try to help you sort that out. By the way, the law does have some teeth. It's actually a Class A misdemeanor to violate the conflict of interest statute, and that is one that you get to share another personal anecdote. My daughter recently turned 18. I asked her what this meant to her, and she says it means she can buy a beer, a lottery ticket, and she has to go to the big jail. So you can tell how well we've done raising her so far. But a Class A misdemeanor is the big jail. I mean, it does include jail time, and it does have some serious consequences. So please be careful about that. I'm going to talk a little bit about disclosures, and I'm going to hit this one very, very briefly. But there are disclosure requirements in Chapter 176 of the Local Government Code, and to a lesser extent in our ordinance. And that is that if you're on a board or an elected official, or case of the city manager or myself, if we have relationships with businesses that simply do business with the city, then we are required to disclose that. There's also a requirement that if you have received either compensation or have a business interest or gifts from businesses that do business with the city, whether they come before your board or not, and this is the one that's going to probably scare you a little bit. I don't want everybody rushing to the city secretary's office, but whether they do business with your particular board or not, you're required to disclose that relationship. In other words, if you happen to have an interest in a paving company, for example, and that paving company does business or proposes to do business with the city of McAllen, then you're required to simply disclose that in the form of an affidavit that's filed with the city secretary. This involves, and again, you can track the references and the here-tos and the therefores, but the bottom line is that it applies to virtually all city boards, commission members, and administrative heads of certain departments. And it does include gifts, by the way, and no, there is no threshold for a nominal gift. If you receive a gift of any description from a business that does business with the city of McAllen, you're required to disclose that. I'm going to pick on the city manager here because he does this, fills these out regularly, at certain times of the year, around the holidays. Vendors will send gift baskets, they'll send gift certificates to City Hall. Normally, on the staff side, what we do with those is we give them away. We donate them to charity, or we raffle them off, and not raffle, yeah. Well, that cat's out of the bag, I guess. So, no, we put all of the staff members who are not subject to the conflict of interest rules name in a hat, and we let them draw that out, and we give those away. And in the rare cases where, for some reason, that's not appropriate, then we'll fill out a form and make that disclosure. And in a lot of cases, we do both. We'll fill out the form that such and such sent us a gift basket, and we had a drawing and gave it away to someone or donated it to a charity. And by the way, I was watching myself on the video from the last time, and I want to explain this part again because I do think it is important. And that, like I said, there's no nominal amount for that. So if you serve on a city board and someone in the business that does business with the city gives you a $10 Whataburger certificate, that you are required to disclose this. Or if they take you to Whataburger and buy you a, what is it, Mike, a number 7 or whatever it is, that the city manager loves so much, well, you're required to fill out a form. That's why you'll notice the city staff folks, for the most part, simply won't do that. I virtually never allow anybody at a business lunch to buy lunch. I'll, split the check or whatever, and I, just tell them it's easier for me to pay than it is fill out the form. So there is no nominal amount on that. There is an exception, and that is that if it's done for purely social reasons or out of friendship or long-standing personal relationship that you have with someone, well, that is an exception. I mean, if your next-door neighbor has for 20 years brought you tamales for Christmas, and now you're on an advisory board and they bring you tamales for Christmas, and it just turns out that they happen to own a paving company or whatever, well, that you would not necessarily be required to disclose that. Again, as I'll mention in a minute, nobody ever went to jail for disclosing something that they shouldn't have. Lots of people end up in jail for not disclosing things they should have. So I always urge caution even in those situations. Again, it's very simple. You fill out a disclosure form, you sign it, you file it with the city secretary. Also applies to vendors, and I'm not going to touch on this except to say that the vendors themselves are required to make these disclosures as well. And by the way, I will be happy to answer questions at the end or informally if you want to do that, because I am going through this pretty fast. Public Information Act. Third topic I want to touch on very briefly is the Public Information Act. The Public Information Act is that act in the state legislature, and there's a similar federal act called the Freedom of Information Act that basically says that any information, and we used to think of it as documents like this, but of course in the electronic age, that includes any kind of information that the city collects or has in its possession is presumed to belong to the public, and the public can trot down to City Hall and get it if they want to do that and pay, the fee that it cost us to produce that information for us. So the short version is just about any type of information that we have at City Hall or that you have as a board member or senior staff member or otherwise in your possession or in the city's possession related to city business is considered to be public information, okay? And by the far and away the largest issue on this that you probably want to think about these days is that it does include these two items here: emails and text messages. If you have an email account, if you have a city email account, the entire account belongs to the city, and every single email that goes through there is subject to the Public Information Act. Now let me talk about your personal email accounts, because many of you that are particularly on advisory boards, you don't have a city email account, but you have a personal Gmail account or AOL or whatever. And from time to time, you may email back and forth to the staff people that serve your advisory board, hopefully not other board members, we're going to talk about that in a minute, but to the city staff. Even email that comes from your personal email account, from or to your personal email account, if it's related to city business, then it is considered to be public information. And we, as the city government, have an obligation to, first of all, to retain it, but also to go and look for it and get it and produce it if our friends at the Monitor or Channel 5 or whoever it is ask for it, or any other member of the public, then we will go and ask for it and produce that. I've tried to capture this as succinctly as I can in this statement, but the bottom line, again, the easy version is if it's related to city business, you should consider it to be public information. And yes, it does apply to text messages. If you text someone on the staff or if you text a city employee related to city business, then that's considered public information, and we are asked fairly regularly to produce that. The city commissioners that are here in front of me know this firsthand. Once every 6 months or so at least, we will contact them and say, we have a request for all your text messages related to city business, and we need to produce those. Again, I don't want to beat this to death, but I want to emphasize it doesn't matter who owns the cell phone, the PDA, the mobile device, the laptop computer, it makes no difference. If there's city information on there, then that information is considered to be public, and we have an obligation to produce it. It's determined, as I mentioned, by the content, and there is also a retention requirement. I'm not going to hit this very hard, but I guess the most practical way I can put that is don't think that deleting I got a request, so let me go delete them all real quick. Not a good idea, because there is a state law requirement that public information be retained. So if you got questions about that, see the city secretary or my office. I want to hit now the final of my 4 topics, and that's open meetings. Again, it's very, very easy to summarize this, and if you keep this in the back of your mind, you won't get into any trouble in open meetings areas. This is, by the way, covered under what's called the Texas Open Meetings Act. And the short version is do the public business in a public meeting. I mean, that's the short version. There's all kinds of rules and posting and exceptions, but if you have in your mind, look, when I'm doing city business, I'm going to do that in the open public meeting. Then you'll find that this won't be a problem for you. There are, and I put a little definition up there, but there are really 3 elements to the Open Meetings Act. One of them the city takes care of in effect for you, and the other 2 you're responsible for. The 3 elements are the notice of the meeting, which we on the city staff do for you. We post the public meetings for you so that you don't have to worry about that part of it. They have to be posted 72 hours in advance. So those of you particularly in the room that are chairman, or you have other members and you say, well, we'd like to meet, and can we meet tomorrow, whatever, you're probably going to hear from your board. If you don't have a regular meeting time, obviously, you'll hear somebody from the staff say, no, we need at least 72 hours. This is why. The Open Meetings Act requires notice to be posted at least 72 hours before the meeting. And it has to be sufficient to inform the public, and that's why you have the agenda posted along with the notice. You can't just put up we can't just put up a notice that says, hey, the Planning and Zoning Commission is going to meet Tuesday, and that's it. It has to contain a list of all of the specific items that are going to be discussed so that the public knows what it is you're going to discuss. There is always a risk if this isn't complied with that the action taken is voidable. There is a manner in which emergency meetings can be posted. Most of your boards won't be involved in that, but if that does become necessary, you can let us know and we'll talk about that. Now, the 2 things that you're responsible for related to open meetings are this, and that is during the meeting, only discussing those things that are on the agenda. This relates back to what I said earlier. The fact that you have a meeting posted doesn't mean that you can then launch off and talk about anything that you want to talk about or deliberate any topic. You have to stick to the agenda. Those boards that have attorneys, which is most of them, or staff members, you know, if you watch carefully, you'll notice every once in a while, you know, when the attorney starts clearing his throat or doing this or whatever it is that he does, it means that you maybe have wandered off of the agenda and put yourself potentially in violation of the Open Meetings Act. So stick to the items on the agenda. The one and only significant exception to that is that you're always allowed to discuss an item for the sole purpose of instructing the staff or the other board members to place it on a future agenda. So you can do that. But other than that, it all has to be discussed from what's on the agenda. And it all has to be done in open session. The vote has to be taken in the public, and members of the public have to be allowed to attend. Now let me, again, kind of dispel a little urban legend about this. A public meeting and a public hearing are 2 different things. A public meeting is just a meeting that is open to the public. They can come, they can sit, they can observe, they can videotape, they can, you know, take notes, but they are not necessarily entitled to participate in the meeting. A public hearing, and these come up in zoning matters and variances and things like that, or where members of the public are allowed to express their opinion on that particular item that's being discussed. So while most all of your meetings are open to the public, actually very few of you have meetings that are public hearings. You are allowed to conduct a limited number of types of items in executive session. Again, your attorneys or staff will help you with that. I've listed some of them here, but the vote always has to occur in the public meeting. So your first responsibility is sticking to the agenda, deliberating in the open meeting, and voting in the public portion of the meeting. Your second obligation is to not conduct city business outside of the open meeting. And what do I mean by that? Here today, we have, I'm sure, a number of boards who have most or all of their board members here. It would not be appropriate for you all to go huddle in the corner and discuss the city-related business that you think may be coming up. You're not allowed to do that. Take on another item that we are asked very frequently. The fact that a quorum, if your board happens to be 5, and, well, let's say your board happens to be 7, and there's only 3 of you there, so that you don't have a quorum, That does not necessarily mean that you're not violating the Open Meetings Act by the three of you discussing that particular item. The Attorney General is very, very, what's the word, persnickety about this sort of thing. And if they or more to the point, the local DA can determine that you're discussing items among 2 or 3 members and then calling another member and, you know, what they refer to as a walking quorum, that can be a violating of the act. Again, what was the very first, you know, statement that I made? Do the public business in the public meeting and you won't have to worry about that. You can't take straw votes this refers to the executive session. You can't take straw votes, but you can express your opinion in the executive session as long as you vote in the open session. Again, there's some teeth in this act, and in fact, there's a fairly major litigation going on right now where some other cities, not the city of McAllen, is attempting to overturn the Open Meetings Act. I would not bet my next paycheck on that being successful. But nevertheless, it is a major topic in the legal community. And it does, again, like the Public Information Act, it does have teeth. You can be found guilty of a misdemeanor by violating these provisions. I thank you very, very much for your patience and your time. I'd be happy to answer any questions when we conclude. Thank you.